In this lecture, we're going to be looking at Chapter 2, the Founding and the Constitution. This chapter starts with a discussion about the possible removal of a statue of Thomas Jefferson from the City Council chambers in New York City Hall, and it presents two different sides of the argument. Some wanted it to stay, saying that it was celebrating Jefferson's contributions to the founding of the country, while others wanted it removed because he was a slave owner and supported the removal of indigenous individuals. And so why we start with this story, the point of it is that we need to remember that the founders were flawed, and the beginning of our country is often troubling and complex, often more than we are taught in our history classes. So when we look at this, right, when we look at the first founding, we need to look at different interests and conflicts. When we examine the founding of the country, we need to remember two additional processes that are occurring at the same time: the land removal from native nations and the enslavement of Africans. So with the native nations, before the arrival of Europeans, hundreds of independent native nations existed, consisting of millions of native peoples. In fact, there were over 60,000 Native Americans living in what would later become the New England colonies. When the colonists came, what did they bring with them? They brought many diseases. And the natives didn't have any immunity to them. So why most of the natives were wiped out were actually from the diseases that were brought over. For an example, there were 12,000 natives when Jamestown was settled in 1607, and only 1,000 natives remaining in 1700. Settlers also rejected the idea that the natives owned the land, and they forcibly removed them. This is called settler colonialism, which means it seeks to remove the native people and replace them with a new settler population. And at this time, we have to remember, land was the most valuable commodity in America. Also during this time period, we have the British taxes and colonial interests. The British government needed more money, so in 1760s they turned to the colonies to get this money. And we need to remember that governments largely relied on tariffs, duties, and other taxes on commerce to raise revenue. And so they imposed the Stamp Act of 1765 and the Sugar Act of 1764 on colonists. At this time in the colonies, we mainly had two what we'll call kind of political groups. We had what we considered the radicals. These were often small farmers, shopkeepers, and artisans. They had fewer economic resources and were distrustful of the British rule. And then we have the colonial elite. This was made up of merchants, planters, and royalists, and they often benefited from British rule, and they supported the crown. With the additional taxes being levied, and acts of British government led to further unrest in the colonies, and eventually this leads to the Boston Tea Party in 1774 and the convening of the First Continental Congress. And then we also have to remember we have the enslaved Africans in the colonies. Profits gained through slavery were critical to the early development of the colonial economy and made it possible to imagine a future without British rule. In 1619, 20 to 30 slaves arrived in Jamestown, Virginia, and this marked the beginning of the transcontinental slave trade. Slaves were considered property that could be bought, sold, and insured, and they had absolutely no legal rights. Enslaved labor was responsible for the major agricultural exports of the colonies too. These included tobacco, rice, sugar, coffee, silver, and gold. And they were also essential to support manufacturing. In fact, New York was the largest slave-owning colony in the North. Slaves also literally built the plantations in the South, including the homes of George Washington and James Madison. So we need to keep these in mind as we're looking at the foundings of the nation. So then we'll look at the Declaration of Independence. In 1776, a Second Continental Congress met, and on July 4th, 1776, signed the Declaration of Independence, which was mostly written by Thomas Jefferson. It legitimized the separation from Britain and announced the creation of a new nation. The declaration was remarkable because despite the colonists' difference along regional, economic, and philosophical lines, it focused on the principles, goals, and grievances that unified the various groups. So even though we had all these differences, in fact, these grievances and the goals unified them. It makes the claim that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. And in 1776, this was a very dramatic statement. The Declaration of Independence states that the purpose of government is to secure these rights, and that governments derive their just power from the consent of the governed. If the government violates these rights, then the people have not only the right, but the duty to overthrow them. And then the Declaration went on to list 27 grievances against King George. And now we have to remember, at the same time the founders were making these claims, they were also limiting the sovereignty of the native nations, and slavery was legal in all 13 colonies. And most of the signers of the Declaration, including Thomas Jefferson, owned slaves. All right, some of these ideas for things such as the Declaration of Independence come from the influence of Enlightenment thinkers, most especially the social contract theorists. Social contract theorists believe that people give up some rights and freedoms in exchange for an ordered society. Now, we've already mentioned John Locke, his date 1632 to 1704. We mentioned him a little in chapter 1. He was British, and he was a social contract theorist, and much of Jefferson's writing and ideas are based on his works. Locke says life, liberty, and property, and the idea that people have a duty to throw off an unjust government. We also have Thomas Hobbes. His date's 1588 to 1679, and he was also British and also a social contract theorist. And he wrote about governments being necessary. Why? Because he said man's life in nature is solitary, poor, nasty, brutish, and short. And he believed, right, that governments, by coming together and forming governments, could help it so this life was not, as one of my professors used to say, cruel, brutish, and short. And so people came together and formed governments for their benefit. He did believe, though, that governments should have limits to their power. And then finally, we have Montesquieu. His date, 1689 to 1755, and he was a French philosopher. And he advocated for the separation of powers in government, including the separation and the elevation of judicial power. In Britain at this time, it was still held by the monarch, by the king. These ideas were very influential in establishing what will eventually be the three-branch system of government. But before we get there, we first have to look at the Articles of Confederation. In November of 1777, the Continental Congress adopted the Articles of Confederation, and this was the United States' first constitution, if you will. It was ratified by all 13 states in 1781, and it lasted until 1788. In this, what we saw was there was this great fear of a central government having too much power. Remember, they're coming from the rule of a king that had pretty much ultimate power. So they didn't want to have a new government that had a lot of power. When we talk about a confederation, what we're talking about is a system of government in which states retain sovereign authority except for powers expressly delegated to the national government. There was no president or presiding officer. The entire national government consisted of a Congress which actually had very little power. They could declare war, make peace, negotiate treaties and alliances, issue currency, borrow money, regulate trade with Native Americans, and appoint senior officials of the United States Army. However, there was no United States Army, only state militias. They could not collect taxes, and each state only had one vote. In those, and Congress's salaries were paid by their state. They were also subject to immediate recall, so if they did something their state didn't like, they automatically could lose their jobs. Also, any amendments to the Article of Confederation had to be approved by all 13 states. Basically, under the Articles of Confederation, they limited the power so much that it was hopelessly impractical and ultimately failed. Because of these issues and more, Virginia in 1786 invited representatives from all the states to a convention in Annapolis, Maryland. We also see the influence of Shays' Rebellion. We have Daniel Shay, who was a former Army captain, and he led a mob of debt-ridden farmers in an effort to prevent their foreclosure on their land. They attempted to capture the federal arsenal at Springfield. The state government regained control eventually and captured 14 of the rebels. However, what this proved was that Congress, as formed under the Article of Confederation, was completely unable to act decisively in this time of crisis, basically showing that the government really had no power. So states were then asked to send representatives to Philadelphia to discuss constitutional revisions in every state since representatives except Rhode Island. So now in May of 1787, we have the Constitutional Convention. The delegates, though, soon saw that there were just too many flaws in the Articles of Confederation, and they decided that there was no way they could fix them. So they basically decided to throw it out and start over. So we had a couple different plans that were proposed. First, we had the Virginia Plan, which was proposed by Edmund Randolph of Virginia. In this, the proposed representation national legislature be based on the population of each state or the proportion of each state's revenue contribution to the national government. It also proposed a second chamber of the legislature that would be elected by the first chamber. So Congress would have two chambers, making it a bicameral legislature. And this plan was heavily biased in favor of the larger states because it's based on population. States with larger populations are going to have more representation. And so because of that, we get the New Jersey Plan. And this was proposed by William Patterson of New Jersey. The less populous states feared under the Virginia Plan that the larger states would dominate. So what they proposed in the New Jersey Plan was a single chamber or house in the legislature, and there be equal representation for each state regardless of population. So under this, 13 states, they proposed, well, maybe every state gets 2 representatives no matter what the population is. And so this leads to what's called the Great Compromise. And basically they put the two plans together. We have a bicameral legislature, so meaning 2 chambers. We have the House of Representatives with seats apportioned according to population size. And then in the Senate, each state would have equal representation. So here we saw each side got what they wanted. Also, some issues that arose with creating the new government was the issue of slavery. Slavery was still crucial for the colonial economy. At the same time, there were shifts, though, in attitude towards the acceptability of slavery, especially in the North. We saw at this time calls to end the transatlantic slave trade. Also, we see resistance by the slaves themselves. There was some obvious resistance, such as running away in armed massed uprisings, and then some that were more subtle. Some learned to read, which was illegal, destroying tools, and also slowing down the work pace. Also, slaves that fought for the United States during the Revolutionary War were offered their freedom. They were tried to motivate them to fight in exchange for freedom. After the war, Vermont, Rhode Island, Massachusetts, and Pennsylvania all outlawed slavery. So here we see the national divide over slavery. And we also have 2 different views of slavery, looking at slavery as an economic value and then looking at slavery for the morality of it. This leads to the 3/5 compromise. So the question was, if we're going to have representation by population, do slaves count in the population for deciding representation for the House of Representatives? More than 90% of the slaves lived in 5 states: Georgia, Maryland, North Carolina, South Carolina, and Virginia. And the slaves accounted for 30% of the total population. So the delegates from these states wanted them counted as free persons for determining population. They didn't want to treat them as free, but they wanted to count them as free, so that way their numbers would be higher and they would get more representation. Delegates from the northern states had varied opinions, but most did not want the slaves to be counted as free persons. What it would do, it would swell those 5 states' population numbers. However, southern delegates claimed they would never ratify a new form of government if the northerners refused to give in. So this led to what's known as the Three-Fifths Compromise. What this was is seats in the House would be apportioned according to population, in which 3/5 of enslaved people would be counted. So southern states gained added influence in the House, but not as much as they wanted. And this remained in effect until 1868, with finally the ratification of the 14th Amendment. With the slave trade, many delegates were appalled at the idea of accommodating an extension of the slave trade in the new Constitution. Others, though, saw it as the key to their future economic livelihood. At the time of the convention, 10 states had already outlawed the importation of African captives, and we had Georgia, North Carolina, and South Carolina still allowed it, and they threatened to walk out if it was limited. So what they did is we have another compromise. This compromise said the importation of enslaved black people was allowed to continue for another 20 years. The federal government was granted increased authority to tax imports of enslaved Africans. So with this compromise, the slave trade continued for 20 more years. However, it didn't make it as financially lucrative. This also had lasting consequences that we still see to today. Basically, the Constitution entrenched and protected a dehumanizing institution that violated the liberties of black people. More than 1,700 men who served in Congress in the 18th and 19th century were slave owners, and this wove white supremacy into the fabric of the new nation, solidifying a system of racial hierarchy. All right, now we're going to talk about creating a new government. So what the framers wanted to do is they wanted to promote commerce and protect property from radical state legislatures. This led to national control over commerce and finance, national judicial supremacy over state courts, and a strong presidency. Basically, they wanted to avoid the failures of the Articles of Confederation. And you can look at chart 2.1 in your book for a little more information on this. They also created the checks and balances that each branch of the government is able to participate in and influence the other branches of the government. So, for example, the Supreme Court can use the power of judicial review to declare any law and any act of any government official unconstitutional, thereby making it null and void. So if we have a law that's proposed by the legislature and both houses pass it, both the Congress and the Senate, and then it's signed into law by the president, if the Supreme Court says it's unconstitutional, meaning if it goes against the Constitution, then it's no longer valid. It is null. So it gives the Supreme Court power over both the legislative and executive branches. And we see through these checks and balances and separation of powers, this is true for all the branches. What we mean by a separation of powers is the division of governmental power among several institutions that must cooperate in decision making. And also we have the idea of federalism, which we'll talk in much more detail in Chapter 3. Federalism is a system of government in which power is divided by a constitution between a central government and regional governments. All right, let's look briefly at our different branches of government. First, we have the legislature. As we already said, it's made of two chambers, the House of Representatives and the Senate. The House of Representatives, their term is for 2 years, and they are elected directly by the people. They also had the sole power to ordinate revenue bills, and they were designed to be directly responsible to the people. That's why they get elected every 2 years. And then we had the Senate, whose terms were 6 years. And originally, senators were to be appointed by state legislatures. That changes in 1913 with the 17th Amendment. And the idea why they wanted them to be appointed was it was supposed to be more resistant to popular pressure than the House. Also, the Senate has the power to ratify treaties and approve presidential appointments, such as justices to the Supreme Court. Section 8 of Article 1 specifically lists the powers of Congress. We also have what's called the doctrine of expressed powers. And what this means is the Constitution also implies that any powers not listed were not granted at all. And then we have the elastic clause. The elastic clause, though, says that Congress can write laws needed to be able to carry out its expressed powers. It meant to be a source of strength to the national government, not a limit on it. And then the 10th Amendment states that the powers not specifically granted by the Constitution to the federal government were reserved for the states or the people. All right, then we have the executive branch. Again, this was a new branch of the government that was not in the Articles of Confederation. Article 2 of the Constitution provides for the presidency. And the framers wanted the president to be able to make timely and decisive, or to take timely and decisive action to deal with national issues and problems. Where under the Articles of Confederation, basically the government couldn't do anything with Shays' Rebellion. They wanted to avoid that, and they wanted the president to be able to take this timely and decisive action. Also in your text, it lists some of the powers, but we'll go over those in more detail in a later chapter. All right, then that brings us to the judicial branch. This was established by Article 3 of the Constitution. The judicial branch has the judicial power of the United States resides in the Supreme Court. The Constitution grants the Supreme Court the power to resolve any conflicts between federal and state laws. Specifically, it can determine whether a power is a national power, a state power, or shared between the two. Federal judges are often given lifetime appointments to protect them from political or public pressure and interference from the other branches. The president appoints these judges and the Senate approves them. And also, their greatest power is the power of judicial review, which I discussed earlier, which, interesting, is not actually in the Constitution. Basically, the court gave it to themselves in the famous court case of Marbury versus Madison of 1803. And we'll also discuss this more in Chapter 13. All right, so with our separation of powers and our checks and balances, again, the framers wanted to guard against possible misuse of powers. And we see, right, how we have guard against these possible misuse of powers are through federalism, the separation of powers, and the Bill of Rights. They believed that power must be used to balance power. Each branch is given not only its own powers, but also some power over the other two branches. So again, an example, the president's veto power over Congress, Congress's power to approve appointments to high executive posts into the judiciary, and the judiciary's power of judicial review. And you can see figures 2.2 and 2.3 in your textbook for more information on this. Also limiting the power of both national and state governments under federalism. What the idea was, you place more power at the national level without completely undermining the power of the state governments. In this, you have two sovereign or supreme powers, the states and the nation, and the hope that the competition between the two would effectively limit the power of each, that one's not going to let the other get too strong. And then also we have the Bill of Rights, which is the first 10 amendments to the Constitution. This is a set of citizens' rights that are protected by the Constitution. All right, so also with the Constitution, we had to ensure national unity in it. And so we have things such as Article 4, which includes the Comity Clause. Each state is prohibited from discriminating against the citizens or goods from other states in favor of its own citizens or goods. We also have the Supremacy Clause, which is also in Article 4. This states the national laws and treaties shall be supreme laws of the land, meaning they're superior to those adopted by any state or other subdivision. All federal, state, and local officials also must take an oath to support the national Constitution. meaning if state law and federal law ever conflict, they must support the state law. So then we're looking at processes for ratification and changes. The Constitution can change, it can be amended. So with the process for ratification, these are in Article 7. In it, 9 of the 13 states would have to ratify it in order for the Constitution to go into effect. Also, the procedures for amending the Constitution are in Article 5. The requirements for this are very difficult to meet. In fact, since 1791, when the first 10 amendments were adopted, only 17 other amendments have succeeded or been adopted. More than 11,000 amendments have been formally introduced in Congress, and only 29 were officially proposed, and 27 were eventually ratified. And you can see tables 2.1 and 2.2 in your textbook. So for ratifying the Constitution, first, it needed ratification by the states' conventions of delegates. These delegates were elected by voters. We had two different sides in the debate over the Constitution. We have the Federalists, who wanted a strong national government and supported the Constitution, and then the Anti-Federalists, who supported a more decentralized federal system and opposed the Constitution. The Federalists were united in their support of the Constitution. However, the Anti-Federalists were not united. They all objected to the Constitution, but for different reasons. Most of them were fearful of a strong system of government that would lead to something like a monarchy, which they just got out of. Because of the debate over the Constitution, this is where we get the Federalist Papers. These were 85 newspaper articles that appeared in newspapers in New York City. They were written by Alexander Hamilton, James Madison, and John Jay, but they were all signed pluvius, meaning of the people or the people. And all of these were articles supporting ratification of the Constitution. All right, some of the topics that were covered or were debated about were things such as representation. Anti-Federalists believed the size and diverse population of the entire nation made a truly representative form of government impossible. However, Federalists saw no reason why representatives should be exactly like those that they represented. They thought through the elections, the voters may choose someone with greater experience and talent, more talent than they had individually, to represent them. As James Madison stated, representatives must be those who possess the most wisdom to discern and the most virtue to pursue the common good of society. Another fear was the threat of tyranny. What is tyranny? It's the unjust rule by the group in power. Anti-Federalists thought the great danger was the tendency of Republican governments to become gradually more aristocratic, basically meaning that the government would eventually become ruled by a small group. And they feared that members of the small group in authority would use their position of authority to gain more and more power over the citizens. Federalists feared that tyranny over the few over the many. Basically what they did is they feared that a popular majority, united and actuated by some common impulse or passion or of interest adverse to the rights of citizens, would trample on the rules of justice. That was the Federalist fear. They saw the national size and diversity, though, as protection over this, that it would be too hard to unite this tyrannical majority. And it's interesting, if we think about these fears today in light of the government, we can see both sides actually had very legitimate claims. All right, and then last we have the fear of governmental power. And this was looking at how do you place limits on governmental action. Anti-Federalists wanted limited government where the powers ought to be confined in certain defined national objectives so that it did not swallow up all the power of state governments. Again, they were very against the supremacy and the elastic clauses of the Constitution. And they demanded a Bill of Rights be added to limit the government's power over the people. believed the risk of the abuse of power was worth taking in order to achieve essential national goals. They saw what happened when they were too weak under the Articles of Confederation. That form of government failed. And so they saw the checks and balances built into the Constitution as minimizing the risk of abuse of any one party or power. They also saw the Bill of Rights, which will eventually become the first 10 amendments, as unnecessary to be specifically spelled out. Why? They believed these protections were already clear in the Constitution itself. So what does this lead to? Eventually this leads to a type of compromise, but ultimately the Federalists won. During the first Congress in June of 1789, though, Madison introduced a proposed Bill of Rights. 3 months later, Congress sent a final list to the states, and then December 1791, the states ratified the Bill of Rights, which were intended to protect individual rights and liberties from governmental overreach. At first, they only applied within the federal government, but after the passing of the 14th Amendment in 1868, many of these protections extended to the states. And what we see in the 14th Amendment, it not only defines citizenship, but it also has the Equal Protection Clause, meaning that who is protected under the rights of the Constitution. And we'll discuss the Bill of Rights in more detail in Chapter 4. So with looking at Chapter 2, I want you to think about, in a lot of ways, this is an introduction to a lot of the topics that we're going to cover in details later on in the semester in specific chapters.